The Offences Against the Person Act. 1861 remains a cornerstone of English criminal law. This act outlines various offences related to violence against individuals. Two key offences within the OAPA are addressed in sections 18 and 20, wounding or causing grievous bodily harm with intent, and maliciously wounding or inflicting grievous bodily harm. While both offences address similar harmful acts, they differ significantly in their elements and potential consequences. Understanding these differences is crucial for legal professionals and anyone seeking to comprehend the complexities of assault law. This essay delves into the distinctions between sections 18 and 20 of the OAPA 1861. It explores the concepts of mental state and physical act within the context of these offences. It also examines case law, the role of psychiatric illness, and the implications of charges brought under these sections. The most serious offence related to causing injury under the OAPA is found in Section 18. This section addresses the act of wounding or causing grievous bodily harm with intent. It carries a maximum sentence of life imprisonment, reflecting the gravity of the crime. To secure a conviction under Section 18, the prosecution must prove both the physical act and the mental element, beyond a reasonable doubt. The of Section 18 encompasses two distinct possibilities: wounding or causing grievous bodily harm. Wounding generally requires a break in the continuity of the skin. Grievous bodily harm is defined as really serious harm and can include injuries that are not necessarily life-threatening but have a significant impact on the victim's health and well-being. The of Section 18 requires proof that the defendant acted with intent to cause grievous bodily harm. This means the prosecution must demonstrate that the defendant specifically desired to inflict serious harm on the victim. Intent is a high threshold to meet and distinguishes Section 18 from Section 20, which requires a lower level of intent. Section 20 of the OAPA 1861 addresses the offence of maliciously wounding or inflicting grievous bodily harm. While similar in many ways to Section 18, Section 20 carries a lesser maximum sentence of 5 years imprisonment. This difference in sentencing reflects the lower threshold required for a Section 20 conviction. Like Section 18, the of Section 20 includes both wounding and inflicting grievous bodily harm. The definitions of these terms remain consistent across both sections. However, the key distinction between the two lies in the required mental state. Section 20 requires proof that the defendant acted maliciously. This means the prosecution must demonstrate that the defendant intended to cause some harm, even if it was not necessarily serious harm. This is a lower threshold than the intent to cause grievous bodily harm required for Section 18. For example, imagine a scenario where one person punches another in the face. If the punch results in a black eye, this could potentially be considered grievous bodily harm, as it is more than just transient and trifling. If the prosecution can prove that the defendant intended to cause some harm, even if only minor harm, then a conviction under Section 20 would be possible. The critical difference between Sections 18 and 20 lies in the required for each offence, refers to the mental state of the accused at the time of the offence. It is a crucial element in determining criminal liability. Section 18 requires proof of intent to cause grievous bodily harm. This means the prosecution must demonstrate that the defendant specifically desired to inflict serious harm on the victim. This is a high threshold to meet and distinguishes Section 18 from Section 20. In contrast, Section 20 requires proof that the defendant acted maliciously. This means the prosecution must demonstrate that the defendant intended to cause some harm, even if it was not necessarily serious harm. This is a lower threshold than the intent to cause grievous bodily harm required for Section 18. The difference in between the two sections reflects the differing levels of culpability attached to each offence. Intentionally causing grievous bodily harm is considered a more serious offence than recklessly causing such harm. This is reflected in the maximum sentences for each offence. Actus reus Defining wounding and grievous bodily harm. Both sections 18 and 20 of the OAPA 1861 require proof of either wounding or inflicting grievous bodily harm. Understanding the legal definitions of these terms is crucial for applying these sections correctly. Wounding is generally defined as a break in the continuity of the skin. This break must be more than a scratch or abrasion. It must penetrate at least the dermis, the second layer of skin. Examples of wounds include cuts, lacerations, and puncture wounds. Grievous bodily harm, GBH, is defined as really serious harm. This is a broad definition that encompasses a wide range of injuries. GBH does not necessarily have to be life-threatening, but it must be more than transient and trifling. Examples of GBH include broken bones, internal bleeding, and serious psychological harm. The severity of the injury is a key factor in determining whether an offence falls under Section 18 or 20. Generally, more serious injuries are more likely to be considered GBH. However, the context of the injury is also relevant. For example, a minor injury inflicted with a weapon may be considered GBH if it is clear that the defendant intended to cause serious harm. Case law plays a vital role in interpreting and applying the provisions of the Offences Against the Person Act, 1861. Several landmark cases have helped to define the scope of wounding and grievous bodily harm and have provided guidance on the application of in this context. In from 1834, the court established that a wound requires a break in the continuity of the skin. This case involved a defendant who bit off a portion of the victim's nose. The court held that this constituted a wound as it involved a break in the skin. The case of in 1961 provided a landmark ruling on the definition of grievous bodily harm. The House of Lords held that GBH should be given its ordinary and natural meaning of really serious harm. This case involved a defendant who caused a police officer to fall from a moving car, resulting in serious injuries. The court held that these injuries constituted GBH. These cases, along with numerous others, illustrate the complexities of applying the Offences Against the Person Act 1861 in practice. They highlight the importance of considering all the circumstances of an offence, including the nature of the injury, the defendant's intent, and any other relevant factors in determining the appropriate charge and potential sentence. The impact of psychiatric illness on criminal liability in cases involving grievous bodily harm and wounding is a complex and nuanced area of law. The law recognizes that individuals suffering from certain mental disorders may lack the capacity to form the necessary for specific offences. In cases involving Sections 18 and 20 of the Offences Against the Person Act, 1861, the presence of a psychiatric illness may be relevant to the defendant's ability to form the required for the offence. For example, if a defendant is suffering from a delusional disorder that prevents them from understanding the nature and quality of their actions, they may not be found to have acted with the necessary intent for a Section 18 offence. However, it is important to note that the mere presence of a psychiatric illness does not automatically negate criminal liability. The prosecution must still prove all the elements of the offence, beyond a reasonable doubt, including the defendant's mental state at the time of the offence will be a key factor in determining whether they are criminally liable. Charges brought under Sections 18 and 20 of the Offences Against the Person Act 1861 are treated with significant gravity by the courts. The severity of the potential sentences reflects the harm caused to victims and the need to deter such violence. As previously mentioned, Section 18 carries a maximum sentence of life imprisonment. Sentences for Section 20 offences are capped at 5 years imprisonment. However, even within these parameters, judges have considerable discretion in determining appropriate sentences. Factors considered include the severity of the injuries, the defendant's intent, the use of a weapon, and any aggravating or mitigating circumstances. A conviction under either section carries significant consequences beyond the immediate sentence. A criminal record with such a serious offence can have long-term impacts on employment, travel, and social standing. Therefore, understanding the distinctions between these sections and the potential ramifications of a conviction is crucial for all parties involved. Sections 18 and 20 of the Offences Against the Person Act, 1861, address the serious issue of violence causing wounding or grievous bodily harm. While appearing similar at first glance, these sections differ significantly in their requirements, impacting potential charges and sentences. The distinction between intending to cause grievous bodily harm, Section 18, and intending or foreseeing some harm, Section 20, is crucial. Legal professionals must carefully analyze the evidence, including the severity of injuries and the defendant's mental state, to determine the appropriate charge. Understanding these nuances is not only important for legal professionals, it is also crucial for potential defendants to comprehend the potential consequences of their actions and for victims to understand the legal avenues available to them. A thorough understanding of these sections contributes to a fairer and more just legal system for all.